Thank you, really, Ribby, not simply for this, but for being an exceptional host. For those at Reichman, thank you very much. It's been a remarkable experience. For those who were here, those who were last night again, thank you isn't sufficient, but I barely speak English, do not speak Hebrew, and know no better words. Now, somewhere around January 1st, 2021, I finished a chapter of a never-ending book project, and the opening sentence of the chapter said that Section 3 of the 14th Amendment was the most forgotten provision of the forgotten 14th Amendment. 14th Amendment consists of 5 provisions, sections 1, 2, 3, 4, and 5, amazingly enough. We only study section 1 and to some extent section 5. No one had ever written anything serious on 2, 3, and 4, and my book project was designed to demonstrate that 2, 3, and 4 were not only the most important to the framers, but in fact expressed a notion of constitutionalism alien to ours, but one that we might want to consider partly recovering. Well, this proved to be one of the least prophetic sentences I ever wrote, because within a week, the insurrection in the United States of January 6th had occurred. And Section 3 declares, if any person who held state or federal office in the past or present participates in an insurrection or rebellion, that person is disqualified from holding present or future office in the United States unless amnestied by a 2/3 vote of both houses in Congress. And suddenly, I was popular. People wanted to know what Section 3 meant. It's sort of like, the strategy I have with fashion. You can try 2 things with fashion. You can try to keep up with the fashion or wear the same suit for 30 years and just hope the fashion comes around and it's in style. Well, that's what I had done. And it turned out that for the first time in American history, the first time in 150 years, a government official in New Mexico was disqualified from holding office under Section 3. I was the expert witness in that case and devised essentially the legal strategy. My dean was very, very pleased because I was a legal historian and now I was doing real work that mattered. But like any good legal historian, I've gotten interested in, okay, what is the academic significance of the real world problem? And what I'd like to talk to you about today is the way Section 3 gets translated, starting with what were their concerns? What are our concerns? How do their concerns play out when we try to make them our concerns? Well, Section 3 was the most debated provision when the 5-provision 14th Amendment was introduced to Congress in late April 1866. Section 1 was hardly debated, but there were a number of crucial issues. First, should the political ban include voting or just office holding? Should the political ban go to all Confederates or a subset? Was this a criminal punishment or a mere disqualification? And Republicans were clear on a number of points. First, the political ban in Section 3 is not a criminal punishment. It's akin to the provision in Article 2 that says you can't be president unless you're 35 years old. Nobody thinks we're punishing younger people for being under 35 by saying you're not being president. It's a simple qualification. We are not punishing doctors when we say you can't be a lawyer unless you've gone to a law school and passed the bar. It's a qualification, and it's very clear that Republicans thought Section 3 was a qualification, and therefore Section 3 hearings are civil, not criminal trials. A second thing that is very clear, and should be very clear to everybody but a lawyer desperate to defend President Trump, was that the president was considered an office holder under Section 3. There's actually a bizarre debate in the United States where some Trump supporters have claimed that the president could take expensive gifts from Saudi Arabia under the Emoluments Clause, which forbids government officers from taking gifts because the president is not an officer. I think this is bizarre as applied to 1787, but it has no possible application to 1868. Andrew Johnson, the president at the time, referred to himself as the chief executive officer of the United States. When asked for people who were officers, they gave examples: Jefferson Davis, Alexander Stephens, the president and vice president of the Confederacy. When bills were proposed for disqualification, the bill sometimes said all officers are disqualified. This includes president, vice president, members of Congress, etc., etc. So there was no doubt in the framers' mind that, in fact, the president was an officer. The third and controversial point is moving from a ban on everybody who participated in the Civil War from voting to a more limited ban on office holding by a limited number of people. Why did they do that? They did that for a number of reasons. One, they found the voting ban would not be enforceable. A second reason is that Northerners, liberals, radicals, conservatives, had a theory of the South. It's a theory that did not begin in 1866. It's a theory that was basically Northern attitudes in 1850. And that is, the South was a land of elite domination. Most Southerners did not want to secede. Most Southerners did not want to fight to the death for slavery. They were manipulated into fighting to the death by a slave-holding elite, an elite that held all the economic power, all the media power. The same people who owned the big plantations owned the newspapers. All the political power. The same people who owned the big plantations and owned the newspapers were in the state legislature and representatives for Congress. And the theory was, if you neutered the slave-holding elite, the rest of the South actually had attitudes on race and free labor similar to the average Northerner. Maybe a little more conservative, but not much more so. That if you just got rid of the slave-holding elite, a new generation would come to power in the South, and they would be sympathetic to Northern policies. Now, When Donald Trump's minions invaded the Congress, none of this was at issue. Instead, there was a different issue. What was an insurrection? Was January 6th an insurrection? Wow.
Yeah. Time flies.
Time flies when you have
Yeah. This was, okay, debated? Not at all. Because everybody thought they knew. The Civil War was an insurrection, but it turned out insurrection had a broader meaning, and the Congress deliberately decided not to say this insurrection, but all insurrections. An insurrection involves an assemblage, more than one, committed to resisting the implementation of a law, any law, by force or violence and for a public purpose. So if you're resisting the tax law because, frankly, you don't want to pay, you're a criminal, but you're not an insurrectionist. If you're resisting a law because you believe Donald Trump was rightly elected president, that's a public purpose. You're an insurrectionist. Moreover, 19th century free speech law made it very clear. Anyone who urged an insurrection, anyone who encouraged insurrectionists was an insurrectionist. You didn't have to throw the punch. You didn't have to hit any congressman. So, in fact, on the trial I was involved in, the evidence showed the person was there cheering the people beating police on. Good enough. Now, here is the interesting problem that I have 2 minutes left, but I'll just toss it to you. The really fun news is if you are an originalist, like a majority of the Supreme Court claims to be, it is open and shut that they need to say immediately today, Donald Trump is disqualified from holding office in the future. It was an insurrection. He participated in that insurrection according to 1868 rules. I looked at all the legal texts with one exception. They are unanimous, and the one exception says that everybody else's rule describes a law of the land, but I don't like it. But it's a good progressive. I'm not an originalist. I think it's incoherent. I think it's stupid. I think that the real meaning of originalism is we confuse things. We think like, here is the original document. That's not what originalism means. It's, here is an original idea. If we look at the originals of the Supreme Court, it is, we've come up with an interpretation of history nobody else has ever thought of. It's original. I'm trying to get that one to sell, so you know, if you spread that one, please go on. But so how do we think of this in a modern time? And I'll suggest a different way of thinking of Donald Trump's culpability. One of the virtues of Section 3 is precisely that it's only a civil penalty. All you do if you're disqualified under Section 3 is you can't be President of the United States or in the state legislature or anything in between. There are lots of other things you can do. And so it strikes me that while most of us have free speech rights, and the 19th century understanding of advocating insurrection would violate free speech rights, we don't think the chief of police has the same free speech rights. It might be okay, to follow Alone's very wonderful paper, for a citizen to say, we're not going to obey that law. It's not okay for the chief of police to say, we're not going to obey that law and we're going to resist violently. So one way of understanding Section 3 is that if you are a member of the government with the power to implement and affect the law. You must use your powers. You are not allowed to tell people to, in fact, seek a change in the law through violence. And anybody who holds those office and attempts through violence or through advocacy of violence to affect the implementation of the law is properly determined not to be qualified for the presidency. And with some luck, I'll finish another book, and this will be in it. Thank you very much.